Welcome back to the channel. Strap in, because today's courtroom chaos comes with an audience nobody expected. We've got not one, but two sovereign citizens melting down in real time, one wide-eyed rookie who thinks she's cracked the legal code, and one repeat offender who treats jail like a punch card program. And just to make it better, a group of kids on a school field trip is sitting in the gallery, front row seats to a masterclass in exactly what not to do in court. What starts as a routine hearing turns into a live demonstration of delusion, entitlement, and immediate consequences. Let's get into it.
City County versus Amber McHenry, case number 24 TRD 819. Ma'am.
I'm sorry. I'm just trying to get my stuff situated so it's ready here.
Take a seat
I have a question.
in this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit
same
down.
rights there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges
I
filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, Ms. Ma'am?
Because I did not enter that plea.
Okay, so you tell me how you would like the plea: guilty, not guilty, or no contest.
First I have to correct the standing, which is I am not the ens legis non degere. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
Well, you can settle your dumbass in Somalia, where you and your fellow sovereign fucktards might get a little bit of sympathy from the populace for your anarchist beliefs. But here in America, we're just gonna point and laugh at your dumb
If you want to live in a fantasy where made-up laws and YouTube-certified legal theories actually matter, feel free to build a world somewhere else. Because in the real one, especially inside an American courtroom, there are no gold stars, no sympathy points, and no alternate rulebooks. There's reality, consequences, and a judge who's heard every version of this nonsense before. Keep clinging to the delusion, and all you're really doing is putting on a public performance while fast-tracking yourself back into handcuffs. Case dismissed. Lesson ignored.
Sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. I do not understand.
I will set this case for a bench trial. and
No,
we'll get this set.
I have the right to a trial by jury.
Okay. No, you don't. Not in this case. Now,
Yes.
these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case, but then because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and court costs.
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. Involuntary can't be violated, basically, is what it means. So I have the right to a jury by trial
No, you don't.
of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they're going to give you a trial date. Okay? So,
Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre. I told
That-
you that.
I don't know what that means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me.
If the judge ditched the bench, started snacking on paint chips, and spent his days doom-scrolling conspiracy forums, then maybe, he'd be on the same wavelength as this defendant. But thankfully for everyone involved, the judge still operates in reality, precedent, and actual law. And that's exactly why this entire performance collapses on itself. When fantasy crashes into facts, confusion isn't a mystery. It's the only possible outcome.
Great.
Yeah.
So
Ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know there's not.
You're looking at the contract. You're looking at the one who's going to be able to, has the authority to be able to put you in jail and I'll hold you in contempt. So let me say it one last time because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
You are not the beneficiary, and nor am I the trustee.
Yes.
Yeah.
I don't know, Judge. You only went to law school, handled real cases, and probably drafted more trusts than this woman has coherent thoughts. But Karen here rolls in with full sovereign citizen energy, trying to reinvent fire with a Bic lighter while spiritually opting out of the legal system. She's convinced confidence equals competence and volume can replace facts. And yes, someone in this room is wildly out of their depth, but let's not pretend it's the person wearing the robe.
Go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Also love how this troglodyte Karen didn't show up alone. She brought her fun-sized Neanderthal sidekick along, like a pocket caveman for emotional support. Maybe by the time her trial rolls around, he'll evolve opposable thumbs and a basic grip on reality. Fingers crossed. And with that circus wrapped up, let's head over to Judge Shackelford's courtroom, home of our all-time favorite sovereign citizen flute player, Eric Martin. You remember him. Judge Slavin already sent him to jail weeks ago after rejecting every last jurisdiction fairy tale he brought to court. He finally got released, and within 24 hours, he violated his bond on a domestic violence case and proudly marched himself right back into a cell. Absolute peak, Eric.
Peak, Eric.
All right, this is 242448SM, the people versus Eric Martin. Mr. Martin, can you tell me your name?
I'm a Roman cystic if that's what you're wondering.
Okay, I recognize Mr. Martin. Mr. Martin, it's my understanding that Mr. Coots, an attorney, a defense attorney, attempted to meet with you to go over your rights and that you did not want to meet with him. Is that correct? Yes or no?
Well, at first I did, and then I kind of changed my mind. I'm still in the sense of not giving you guys the fraudulent presumption that you got jurisdiction over me.
Let me stop you right there and have you look around. Notice where you're standing, and notice where the judge is sitting. That difference? That's jurisdiction. Loud, clear, and already settled. And honestly, when Eric Martin got dragged in on his first bond violation, I said it then, this guy doesn't even acknowledge that the court exists. So was anyone actually shocked when he ignored the order? Are we really supposed to act surprised when he boomeranged straight back into a jail cell? When someone lives in permanent denial of reality, the outcome isn't unpredictable, it's inevitable.
So no.
Because
I'm going to mute you so I can tell you your rights, Mr. Martin. I need you to listen. So here are your rights. You've been brought to court on an allegation of a bond violation. Specifically, you currently have a domestic violence case pending at this court in front of Judge Slavin, and on that case, the complainant is Kirk Martin. There was a no contact provision, and that was one of the conditions of bond. And there is an allegation that on December 14th, so just this weekend, that someone called from the residence of Kirk Martin and indicated you were in the home. And the officers alleged that you were, that they checked and that you had bond conditions out of this court saying you weren't to be near him, and that you were taken into custody, for violating your bond conditions of no contact with Kirk Martin. These are allegations at this time. But they're serious allegations in violation and no contact provision. So do you want me to enter a plea, or do you just want to ramble about jurisdiction? I'm going to ask you to unmute so you can answer my question. Officer Ziegler, I'm sorry, can you unmute? Mr. Martin, you have options, so you understand that's what you're here on. You can plead guilty, not guilty, or you can say nothing, and I'll enter a not guilty plea on your behalf. So to the allegations that you violated the conditions of your bond for purposes of arraignment, how do you plead?
first I want to notify crimes. Before I get to that, I want to notify crimes committed against me in the jail here since I've been here, such as criminal harassment.
Okay, I'm going to enter a not guilty plea on your behalf.
I'm not done talking.
Because your answer is non-responsive.
Violating my First Amendment right, freedom of speech. And this whole bond order condition, it violates my due process right to be free at my house, which is based on an unsupported lying allegation by my brother. Therefore, this is all violation of my due process rights. The bond order should have never been done. This is all unconstitutional. The case should be dismissed, and I
demand to be released all you want, but your demands and reality haven't been on speaking terms for a long time. You're not in a position to demand anything from anyone. The court already gave you chances, and every single one ended the same way: zero respect, zero compliance, and zero ability to follow even the most basic instructions. So no, what's getting dismissed today isn't your case. It's the incoherent rambling of a fully grown 50-year-old toddler who still thinks volume and delusion count as a legal strategy.
So, sir, you have a right to a hearing on this matter. You have a right to receive written notice of the violation. You have a right to plead guilty, not guilty, or stand mute. I've entered a not guilty plea on your behalf since your response was non-responsive. You also have a right to contest the charges at a hearing. You do have the right to the assistance of an attorney at all subsequent court proceedings, and you can change your mind at any time, Mr. Martin. You have the right to have that a lawyer appointed at public expense if you are unable to afford an attorney. And it's always possible that if the court determines you were able to pay, that you would be required to contribute to that cost. If you continue to proceed without an attorney, you would give up your right to a lawyer's assistance. We will set the hearing. I'm required to set that hearing on that violation. If you are in custody, we must hold it within 14 days of the arraignment, which is 14 days from today, or the court must order you released pending that hearing. If the alleged violation is based on a new criminal offense, that is basis for separate criminal prosecution, I don't have any knowledge that that's the case here. The court could postpone the hearing for the outcome of that prosecution. You have a right to contest the allegations against you. You would have a right to have the evidence against you disclosed. You'd have the right to present at the hearing, or to be present to present evidence, and to examine and cross-examine witnesses. The court would only consider evidence that's relevant to the violation, but it need not apply the rules of evidence except those pertaining to privilege. The prosecuting attorney would have the burden of proving the violation by a preponderance of the evidence. If you pled guilty, you'd be giving up your right to a contested hearing. And while this case is pending, you could be, the most severe violation is you could be held pending the hearing, and if found guilty of this violation, you could be held while this case is waiting for jury trial. So those are your rights, Mr. Martin. Mr. Martin, I understand your sovereign arguments. I mean, it's fine. You can make them. I've heard them before. Everyone at this court has heard them. But here's the thing. I can't have you, if there is a no contact order and you continue to violate the no contact order, I can't let you out. Because you're not listening, and I know you don't think you have.
Standing in the middle of your due process right now. Yes, this is it. And part of that process means doing the bare minimum when the court cuts you a break, like actually following the conditions of your bond. Somehow, you failed that test more than once. That's why nobody here is even considering a PR bond. You didn't just burn that bridge, you rebuilt it, lit the match yourself, and stood there watching it burn to the ground.
This is in accordance with the Constitution, and okay.
And the fact of the liberty right to be home because of an unsupported lying allegation. I'm telling you right now, he told a lie. And I told the prosecutor my brother assaulted me in actuality. First and foremost, he assaulted me. But I had no evidence of it. I don't have him on video evidence. He doesn't have me on video evidence to assault him. So we have my brother saying this, me saying this. We don't know what happened in reality. So the dumb cop should never arrest me. Prosecutors should not be moving forward on this. They're moving forward with it. It's already a malicious prosecution on the prosecutor's part. There's no probable cause because there's no evidence here. Bottom line, we don't know what happened. This is violating my due process rights. I'm being deprived of my freedom to be at the house I've been living at for 32 years. The bond order was legally should have been never been ordered because it's based on, once again, an unsupported lying allegation that has no video evidence, no real evidence to support it. The bond order must be dismissed. I'm supposed to be allowed to go back home and have a right to be. Doesn't matter how many lies are told.
Let me tell you your bond conditions, Mr. Martin. You're to appear in court as directed. All right,
I'll go yourself.
I'll mute you and read them, whether you like them or not. These are your conditions, sir. So I'll just read them into the record and you can choose to listen or not listen. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Whether you like it or not, you're not to have any contact with Kirk Martin or the residence where he resides and where this original allegation occurred, which is 9074 Clippert in the city of Taylor. Sir, you cannot purchase or consume alcohol or illegal drugs. You can't possess or have access to firearms. And you have a $2,000 cash bond. I've noted on the file that you're entitled to this hearing forthwith, so the clerks will give you a date forthwith.
And with that, Eric Martin once again proves he's nothing if not consistent. Same recycled arguments, same open defiance, and the same completely predictable ending. He didn't just ignore the lesson, he dared the system to repeat it, and it happily obliged. So enjoy the extended stay, Eric, because court isn't done teaching yet.